So why don't we go ahead and proceed? We have three cases this morning, which means that we have to be fairly consistent with our time limitations. This one is City of Daytona Beach and Michael Chitwood versus AB and Florida Carry Inc. Case number 19-6. We're set for oral argument this morning. I'm Judge Cohen from Orange County. We've got Judge Wallace from Orange County as well, and then Judge Edwards, the other member of the panel, from Seminole County. Now we've got an appeal and a cross appeal. I don't know, I think someone reached out as to the procedure, and so what I had indicated is that what we would do is to have the appellant go first on their argument, and then they can reserve as much time for rebuttal and then also for addressing the cross appeal. And so you just let us know what you'd like, and we'll be glad to accommodate that. Then the appellant will proceed with response to the initial argument and then proceed with the issue on cross appeal. And the appellant then can reply to the cross appeal issue and do rebuttal on the initial issue. And then the appellee will have an opportunity to respond as to the issues on the cross appeal. Unless you all would like some other process to be used, I'm flexible with it. Mr. Glassman, is that procedure fine with you?
That's fine with me, Judge.
And Mr. Friday, how about you?
That is fine, Your Honor.
Okay. So if you have any type of interruptions or anything, please try to unmute to mute so that it doesn't distract the oral argument. If you can do that, we'd appreciate it. And so that said, Mr. Glassman, you may proceed, sir.
Thank you, Your Honor. Gary Glassman for the City of Daytona Beach and Michael Chitwood. And if it pleases the court, I think what I would like to do is do a 10-minute addressing our appeal. Mr. Friday can then go ahead, and then I'll reserve 10 to respond to his cross appeal.
All right, that's no problem.
Exact like that, but I think that's kind of the way I'd like to do it.
Very good.
All right, thank you, sir. Good morning. I sit before you today feeling somewhat like a character in Mark Antony in William Shakespeare's Julius Caesar. Antony speaks before the Roman citizens and at Caesar's funeral and says, "I have come to bury Caesar, not to praise him," but in reality, he is actually praising Caesar. And today I feel that way because I'm coming before you to ask you to bury part of Judge Orfinger's decision, but also to praise part of Judge Orfinger's decision. So what I would like to do is start with the appeal that the city has made, which is requesting the reversal of the contingency fee multiplier completely. I'd like to address that part first. To begin, I think that it's important that we discuss the issue of whether under the statute, under section 790.333F, Florida statutes, and contingency multiplier is automatic. The statute reads, "A court shall award the prevailing plaintiff in any such suit reasonable attorney's fees and costs in accordance with the laws of the state, including a contingency fee multiplier as authorized by law." It's the city's position and Mr. Chitwood's position that a multiplier is not automatic. And the reason we say so is several. Number one, even in the most recent Supreme Court decision that I've seen on multipliers, the Joyce case, the justices made very clear that while you don't have to have a rare or exceptional case to have a multiplier, it doesn't mean that a multiplier is automatic. I don't know of any case that has been cited or that I've read that says that a multiplier is an automatic part of an award of attorney's fees. The second,
Not many statutes, though, specifically even address the concept of a multiplier, do they?
that's true, Judge. It is I don't want to say it's unique because there could be others. I will concede I have not researched every statute that has an award of attorney's fees and whether it addresses a multiplier. But it is my understanding from the limited research that I have done that it is unusual for it to address a multiplier. But again, I would say that A, the court hasn't said that it has to be. And number two, if you look at the wording of the statute, it says in accordance with the laws that attorney's fees and costs will be awarded in accordance with the laws of the state. And then when it addresses the contingency fee multiplier, it says as authorized by law. I think that if the legislature had wanted an automatic multiplier, they could have simply said so. They wouldn't have those modifiers in the statute. They would have simply said something like a contingency fee multiplier shall be awarded, period. But because they have put in those modifiers, in two of them in the statute, I think that we still have to look at case law to determine whether a multiplier should be awarded or not. So
other than perhaps having a good lobby, why would you suggest that the legislature even addressed the multiplier in the statute at all?
Well, I think that it was raised by Mr. Friday that he thinks it's an automatic. And so I'm just simply saying that I don't think it's an automatic multiplier.
Well, I'm talking about why the legislature would have even bothered to have placed it into the statute to begin with.
I don't know. It's an interesting thing. I don't know why they addressed it. I have not read any legislative history as to why it was addressed. I think that I'm only guessing here, and so I have no facts to back this up, but I think that there was probably a fairly strong lobby that wanted this particular statute. And in doing so, they felt that one hammer that could be used against the local government would be to remind a judge that a multiplier can be used. But again, I don't think that the legislature at all made it clear or attempted to make it clear that it was an automatic multiplier. I just think that they were just emphasizing it, but not making it automatic.
Didn't the judge agree with you on that?
Yes. I believe that Judge Orfinger did agree with us on it not being an automatic multiplier. Correct.
Do you want us to disagree with his ruling on that, or do you want to move
want
on to
you to
something
disagree with that
you're
part.
unhappy with?
Yeah, no, that's not the part I'm unhappy with. It's the idea that a multiplier was given in this particular case at all. Again, I'm addressing that issue mainly because it was addressed by counsel for Florida Carry and AB, and I just wanted to make sure that it was understood that we don't think it's automatic. Perhaps I should have saved that for the second part of my case, but I'm
That's
just—
all right. Go ahead.
All right, thank you, sir. I want to talk then about why I don't think any multiplier should have been awarded in this case. And first I want to I think the law is pretty clear that the burden of proving that a multiplier should be awarded is on the party requesting the multiplier, that they must go forward with some pretty strong evidence to show that a multiplier is appropriate in this particular case. And I'd like to start with the evidence that was discussed about whether AB and Florida Carry could obtain competent counsel in this case, and whether that required a multiplier. My arguments are—
I'll tell you one thing. You know how well that went on the opinion that I wrote that was then reversed by the Florida Supreme Court.
Joyce.
Right.
Yeah, I read the Joyce decision, and to me, what it seemed like, and if you authored the 50CA decision, you'll know it better than I, that what the 50CA was looking at was the idea that multipliers are something which should only be given in rare and exceptional cases where it's to the point where they just couldn't get somebody else, You know,
Right,
this-
and in Joyce, though, the first lawyer that they contacted took the case, and there was no evidence that they had any difficulty whatsoever in obtaining counsel. And the Supreme Court, reversed the opinion that I wrote on that.
Well, in reading that, I think they focused on the idea that there must be some proof that this is a rare and exceptional situation. I think that that's what they were mostly concerned about.
Uh-oh, did we lost Mr. Glassman? All right, let's stop the clock. And perhaps let him call in. I don't know if you can hear me, Mr. Glassman, but we appear to have lost your feed. And when we've had this happen before, we've gotten him on the phone. So if we can have whoever is monitoring this on our end, give Mr. Glassman a call.
We'll work on it, Judge.
Okay, thank you.
Judge Cohen, IT made contact. He's trying to get back on now. There was a power fluctuation here near the courthouse, so he must be close by here as well.
Okay. Well done, Mr. Friday. So Marshall Crawford, has the bridge opened up?
Yes, sir. Finally.
All right. All right, Mr. Glassman, can you hear us?
Yes, I can, and I apologize for that. Apparently, we had a power outage here at City Hall where I'm
All
located.
right, yeah, no problem at all, except now your time is up.
Okay. Well-
I was just kidding. We stopped the clock. All right,
I'll speak a lot faster. I'll speak like I'm still living in New York.
all right, go ahead, sir.
All right, okay. I wanted to focus just on, first of all, one of the issues in determining this multiplier, and one of them in council, whether Mr. Friday was the only attorney that was available for this case. To begin, let me just say quickly that Mr. Friday, and this is, whatever I say about him is nothing personal. I have great respect for Mr. Friday, and I believe in his passion for what he does. I just don't think he's entitled to a multiplier. Mr. Friday always represents Florida Carry, and he testified that way. So, that's an arrangement that he has with them. Mr. Bontempo testified that at his deposition that he sent out an email, but ultimately he only talked to Mr. Friday. So he couldn't really testify as to whether there were other attorneys who were available to him. Mr. Woodleaf, who was their expert, testified that he never investigated the situation as to whether other attorneys were available to him, to Mr. Bontempo and to Florida Carry. And in fact, he said,
Wasn't there testimony though that very few, while there might have been lawyers available, very few did this particular type of work?
there was testimony, I think, by Mr. Friday that his experience, has been that there have been very few attorneys. But my concern with that is that we're looking at what the situation was in 2013 when the case was started. And Mr. Friday never linked that to what the situation was in 2013. He was talking about his general experience over the years that it's hard to get counsel to represent people in these types of cases.
Mr. Glassman, wasn't the testimony in front of the trial court? I believe it was maybe they narrowed it down to 2 or 3 attorneys in the local area that might have handled the case.
Right.
But back then, it was also made apparent that the case law that was out there that dealt specifically with this preemption issue had not been fully developed. And I believe the judge was then looking at, okay, you don't have a body of case law, so an attorney is going to be taking kind of their chances in taking the case, and therefore, I guess Mr. Friday is going to say, based upon his experience, there was nobody really, there was no body of case law, so there was even that much more uncertainty, which would increase the substantial difficulties. It's not he's the only attorney, there's substantial difficulties in finding counsel. So didn't all that kind of, create a perfect storm as far as why he was the one attorney that could handle the case?
Well, first of all, I think that we have Mr. Byers' testimony, which was that there were other attorneys. Mr. Byer was our expert, and he testified that he believed that there were other attorneys, including himself, that could have taken on this particular case.
But did he testify, Mr. Glassman, did he testify that any of those attorneys, number one, would take it on a contingency fee, and number two, advertised or made it known to the public that they took those kind of cases?
I don't think he was asked about the contingency fee part, so he did not answer that. And no, as far as advertising it, I don't think that, he didn't testify, as far as I remember, anything about whether these attorneys or whether he himself advertised that he would take on these particular cases.
So what we have in evidence in front of the court is that Mr. Bontempo sent out a number of emails looking for lawyers, and the only answer he got back was from Attorney Friday. Are you contending that he would have to send out an email, a blanket email to everybody in the Volusia County Bar before he could say, I can't get a lawyer?
No, Your Honor, I'm not contending that at all, because obviously that would be far too burdensome for anyone to do. What I'm saying is that his investigation, he says he sent out an email. He doesn't remember who the people were that he spoke to, if any. It was very vague as to what he actually followed up with, and that he did testify in his interrogatories that the only one he ended up speaking to was Mr. Friday. I don't think that his search was very detailed or extensive and can be counted on to say, okay, this is the only one Mr. Friday was the only one that he could get for this.
All right, now,
particular-
Mr. Glassman, you are within your reserved
Yes.
time.
All right, then I'm sorry about what happened before, and it kind of took us off path here. So I think what I'm going to do is reserve to answer questions after Mr. Friday's had a chance to go. Thank you.
All right, thank you, sir. And I'll, yeah, I'll give you just a little bit extra time, and I'll give Mr. Friday just a little extra time as well.
Thank you, sir.
All right, Mr. Friday?
May it please the court, Eric Friday on behalf of appellees Florida, Carey, and AB. In 1987, the Florida legislature declared the public policy of this state was that local government had no business having firearm policies or regulations. 24 years later, when local government still had not gotten that message, in 2011, the legislature came up with a solution to put penalties into 790.33. And the stated purpose of that statute is, and I quote, to deter and prevent the violation of this section and the violation of rights protected under the Constitution and laws of this state related to firearms, ammunition, or components thereof by the abuse of official authority that occurs when enactments are passed in violation of state law or under color of local or state authority. Despite this clear and unequivocal expression of law, policy, and legislative intent, AB was told that he could not get his property back, his firearm-related property, unless he jumped through the city's hoops. After he jumped through those hoops, the city's answer was, it's still not enough, get a court order. He got a court order for the return of his property. He got a court order that the city's policy was a violation of Florida law. He got a court order that compensated him for his out-of-pocket expenses to repair the property that was damaged. When it came time for the city to pay for its illegal conduct, it argued to the trial court that it knew from the beginning it was going to lose this case. The outcome was never in question, and therefore the court should not apply a multiplier to the attorney's fee awarded. Your Honors, this is a case of true first impression. Despite Joyce and the other cases cited by the briefs, no other court has been called upon to rule as to the proper method of determining a multiplier in a pure public policy enforcement case brought against the virtually unlimited resources of a governmental entity for the specific purpose of enforcing the public policy of the state as declared by the legislature.
Mr. Friday, are you suggesting that the imposition of a multiplier is automatic?
Your Honors, I believe that the language the legislature used if it does not create an automatic requirement of a multiplier, which I believe it does, or at least obligates the court to go through the process of analyzing the case law regarding multipliers. If it's not automatic, it is a very strong suggestion from the legislature that a multiplier should be considered and that the analysis of a multiplier should be used.
Which the trial court did.
Which the trial court did. And Your Honors, that brings up two differing matters of standard of review for this court. To the extent that the trial court made a determination that a multiplier is not automatic, that is reviewed by this court on a de novo standard. Is it or isn't is a question of pure law and de novo. Whether or not a multiplier is appropriate in this case and what that multiplier should be is an abuse of discretion standard for this court to review. Did the trial court so clearly depart from the proper analysis that the trial court must be reversed? The court asked the question of Mr. Glassman, why did the legislature use the language? And Mr. Glassman argued as to the modifying language. My answer to the court to that question would be the legislature used modifying language to say the court, while the court should award, while the multiplier is available and probably appropriate in these cases, the court should still conduct the analysis as already set forth in the existing case law. We have this canon of statutory construction that says that the legislature is presumed to be aware of the law at the time the statute is passed. And at the time the statute was passed, it was pre-Joyce in 2011, multipliers were at least under the Quanstrom and Roe factors, considered somewhat rare. And Judge Cohen, I would say that the opinion in Joyce would probably be more consistent with what the law was in 2011. Obviously, the Supreme Court in Joyce took a different view and said, no, we do believe there are cases where multipliers are clearly called for. And in a public policy case, and this is important because neither Quanstrom nor Roe nor Joyce, while they discuss there are some public policy aspects, they don't directly address a truly pure public policy case like this one.
But they did set forth that for category 1 public policy case, the multiplier would typically be 1 to 1.5, correct?
I believe that is the Quanstrom and Roe language, Judge Edwards. I don't think the Supreme Court has had quite the opportunity to fully vet it in light of the statutory language by the legislature in 790-33, as well as I would point that while Quanstrom and Roe didn't, they addressed public policy concerns in somewhat of a vacuum because Quanstrom and Roe both dealt with insurance company cases. They both dealt with, well, yes, there's a public policy that insurance companies should pay the claims that are owed. The court has never addressed what about the somewhat unique case where you have truly salaried government lawyers defending the government against what is, and found by the trial court to be, a clear violation of Florida law as declared by the legislature. And I would point out to the court that the legislature went to great effort in 790-33 to make clear that this is supposed to be somewhat of a punishment. They are attempting to deter and prevent. Ideally, in the legislature's mind, based on the language of the statute, there would never be one of these cases. That makes these cases especially egregious. When we get to the necessity, and so putting aside the question of whether or not a multiplier was appropriate and whether or not a 1.5 multiplier should be overturned as the city requests, I would argue that a multiplier is clearly appropriate in this case, regardless of the mandatory nature or not. A multiplier is appropriate under the facts of this case. I would also argue that a 1.5 multiplier in this case is an absolute minimum, and that this court should not find that Judge Orfinger abused his discretion by awarding a multiplier that high, while I will be asking the court to, just as Mr. Glassman did, to find that the court abused its discretion by only awarding a 1.5. And I believe the multiplier should be higher. I don't believe he abused his discretion by finding the multiplier was appropriate, nor is the 1.5 multiplier too high as the city claims. This case was hard fought, Your Honors. At no point did the city admit liability. It claimed it was following what other cities were doing. At no point did the city admit it had to return the property. It required a hearing on the issue of replevin just to get the property back. At no point did the city admit that the property was damaged while it was in its possession. It made Mr. Bontempo have a trial and prove his damages. At no point did the city simply say, we were wrong, we broke Florida law, we'll amend our policy, not do it anymore, and ask for a trial solely on the issue of damages. That would have created an early entitlement to attorney's fees, and it would justify a lower multiplier, if any, by early action. The city chose none of those. And in fact, I would say that the Supreme Court's rules regarding contingency fees lays this out, where it caps the amount of fees a plaintiff's attorney can get in a contingency case where there's an early admission of liability and the case proceeds only on damages. Your Honor, I'd like to also address the replevin as a remedy issue. Judge Orfinger found that because replevin was not a remedy specifically provided for in 790-33, the plaintiff's counsel was not entitled to any award of fees for the time spent obtaining the return of the property through the replevin process. The record's clear that some of the property in this case was of sentimental value. It included a World War II battle rifle brought back as a war trophy by Mr. AB's grandfather. He wanted his grandfather's rifle, not compensation for that rifle. Given the legislative language of this statute, I think it was a violation of, number one, an abuse of discretion, and number two, also a violation of the intent and purposes of the statute for the trial court to find that the effort expended to get a return of the property is not compensable because it's not one of the specific remedies. The fact that the court has equitable powers to fashion additional remedies should not preclude an award of fees on that issue.
Was your replevant action part of the main action, or was it a separate lawsuit?
Originally, Your Honor, it was part of the main action. It was dropped as a count after an amended complaint was necessitated post replevant. After the court had ordered the replevant, entered an order to that effect, then it was no longer a valid count, but we still continued to seek attorney's fees for the bringing of that part of the case. And I would
It
point
had
out
initially been part of the action, correct?
it had originally been part of the action, yes, Your Honor. And I would point out to the court, the arguments of, and while it's not this particular defendant here, the arguments in the Dugan case, Dugan v. Bradshaw out of Palm Beach County, involving almost identical actions by the Palm Beach sheriff. In that case, Mr. Dugan got his property back on his own through a replevant action. When he then filed for a preemption action to recover the fees and the damages that had suffered as a result of having to go through the replevant action, the sheriff's defense there was, but wait a minute, this case is res judicata. He's already gotten the return of his property. If he wanted to get damages, he should have brought the 790-33 action while he was doing the replevant action. So there was no way to win, and Dugan was decided while this case was pending, but there's no way to win this argument. No matter which path plaintiffs had chosen, defendants would have had an argument either that, well, it's precluded by the prior action, or, well, you don't get fees for putting it in with this action. In fact, Judge Orfinger's specific questions during the fee hearing and verbal determination, and I don't remember if it was in the order or not, was that you could have pled special damages in the form of attorney's fees for seeking the replevant. Well, in this case, we had a substantial collection of firearms. Most cases like this involve one or two firearms, maybe a single $500 pistol. So the idea is an attorney would have to take the case, the client would have to pay upwards of $2,000, $3,000 to obtain the return of the property, then turn around and claim it as special damages if the court accepts Judge Orfinger's determination that damages are not recoverable unless pled as special damages in a later action under 790-33. Next, Your Honors, I'd like to address the issue of the travel time. The general law is absolutely, as Mr. Glassman and the trial court found, that attorneys are not generally compensable for travel time. However, this gets back to the expert testimony and the witnesses on fees and Mr. Bayer's and Mr. Woodley's testimony as experts. Mr. Bayer actually testified that he had taken such replevant cases and obtained return of property. But importantly, he never testified that he had gained any attorney's fees, nor did he ever accomplish any change in policy. This case attempts to put out of business lawyers who make money charging clients a fee and getting replevant of property illegally detained, because it establishes a definitive rule that cities and counties do not have the authority to do anything other than hold the property until they are legally, until the whatever the issue they're holding it for has passed, and then they must return it. The fact is, Mr. Bontempo testified that he contacted numerous lawyers. Lots of lawyers don't call back on any cases. Lots of lawyers decide that's not a case they want to take. The standard that the city would argue this court should have is that until you actually talk to an attorney, until you get past the gatekeeper and can identify some specific attorney that you asked to take the case who discussed it with you and won't take it, you're not entitled to claim that you had difficulty finding an attorney. The court asked about the advertising question. I specifically asked Mr. Bayer if the firms he identified advertised for cases. Did they put up billboards, advertise in phone books? He even joked about the lack of a phone book or Yellow Pages being not common anymore. The fact is, he admitted, while those firms advertise, they don't advertise for these cases. Now, I'd point to the court that I testified at the fee hearing that at the time we were discussing, there were 3 attorneys in the state taking cases. We've since added 2 more to that total while this case has been pending. This is now 9 years post passage of the statute. At the time this case was filed, no other attorney had filed any 790-33 cases in the entire state of Florida other than myself. The success rate of these cases, not counting the ones that have settled early on, just the ones that have been in the trial courts, the success rate at the trial courts for the cases that I've handled is 1 out of 7 at the trial level, this case being the 1. This is the first case to actually go to trial. This is the first case where fees were awarded by the trial court for one of these cases. Which brings us to the attorney's fees for this appeal. While the ordinary rule is attorney's fees are not obtainable for time spent arguing about the amount of fees, this issue, the issues before this court, is not strictly speaking about the amount of the fee. It is about the legal standard of what actions and activities of a lawyer constitute compensable attorney time and the amount and the mandatory or non-mandatory nature of the multiplier that a trial court should award. We would also argue that the general rule, which is one of procedure, not statute, was implicitly abrogated by the legislature's express declaration of purpose in this statute.
Mr. Fred, I want to alert you that you got about 3 minutes, and I'd add a little bit to it because I'm going to give Mr. Glassman an extra minute or so. But if you want to reserve any time, following.
Yes, sir. I'm almost finished, Your Honor, and I do want to have a minute left. A ruling that time arguing about the amount of fees is not recoverable only disadvantages the attorneys that bring these cases, because the city has no incentive and the counties have no incentive to not appeal these cases if there's no further risk of an increased fee. To the contrary, if there's no risk of an increased fee, attorneys bringing these cases to enforce the public policy of the legislature suffer suffer a continuing deprivation of the effective hourly rate of the fee awarded every time they have to continue to work to fight for the fees that they earned fighting abuses of local authority. And Your Honors, with the court's permission, I'd reserve the remainder of my time for rebuttal.
Thank you, Mr. Friday. Mr. Glassman.
Thank you, Your Honor. And again, I apologize for the power outage here at City Hall. It wasn't just us, it was throughout the department. I want to address first some of the things that Mr. Friday has mentioned and start with the Replent Action, because this is one of the areas where we support what Judge Orfinger did. And there's no question, number one, that there's nothing in the statute, in the Replevin statute, that says that for a Replevin action, you get attorney's fees. It's quite the opposite. Case law has made it, I think, very clear that attorney's fees are not awarded for a Replevin action. You often have a situation where you end up with cases that have multiple claims, some of which are where an award of attorney's fees can be made and some of which are not. And a lot of times what I've read in cases that I've litigated, you see where courts say, well, if you can't really separate out the time, if you can't say, okay, we spent this much on the claim where there is attorney's fees, and we spent that much time on the claim where there is no attorney's fees.
Well, but Mr. Glassman, how you have a sheriff who illegally holds someone's property. what's that person supposed to do? How else do you, go about getting return of your property then?
Well, the way you go about getting
And if you're not going to get attorney's fees, typically the amount of property seized under circumstances such as this, and in many other circumstances, really is from an economic standpoint minimal.
It usually is, Judge, or sometimes it is. To answer your first question, I think the way in which someone does that, as Mr. Bayer said in his testimony, is you go through a replevant action, and there are no attorney's fees provided for in the replevant action. That's what certainly was available to Mr. Bontempo and to Florida Carry to get back the guns in this particular case.
But didn't they rely heavily on 790.33 to prove up why they were entitled to get the guns back?
I think it was actually, Judge, and I've not sat down and split the hours, but initially, I think the case was more about the replevant. That part of the case seemed to be pushed further.
No, I understand that, but in terms of justifying why he was entitled to a return of his weapons, didn't he cite to 790.33?
Yes, but I think that you could have gotten it through the replevant action without going through 790.33. The difference between the two statutes is frankly attorney's fees. In the replevant action, you don't get attorney's fees. In 790.33, you can make the application for attorney's fees if you're successful.
But the 790 provision, gives the rationale and authority for return of the weapons as opposed to the exercise of some discretion by the sheriff.
790.33 makes it pretty straightforward that because the state has preempted all local laws, that the city or the county doesn't have the right to enact its own laws creating regarding guns or the return of guns. I think that what Mr. Friday has said was that the city knew or should have known and had no right to defend this case. And moving away from the replevant, which I still say they had an obligation to separate out those hours. And I think that's what Judge Orfinger did and did correctly. But I do want to move into this argument that somehow the city knew it was wrong and simply over litigated this case or tried this case to the bitter end, an argument that he makes in his brief. I don't think that's the case whatsoever. I think the city had every right and did so to defend this case as they did. There was an original and 4 complaints. Motions to dismiss were filed. This case was not overly litigated or fought to the bitter end. There was the usual discovery. There were 2 or 3 depositions. There was a motion for summary judgment, and then the final trial. I don't see that as being something where the city fought to the bitter end because we knew we were wrong, but we just wanted to make life difficult for Mr. Friday and his clients. We were doing what we were allowed to do. Mr. Woodleaf claimed at his deposition that we should have told the plaintiffs who the individual defendant was that should be sued. Well, that's outrageous. Since when is it my job to tell them who to sue? To me, that's almost a disbarment type of response. But I think that the city was well within its rights to defend this case and that we didn't over-litigate it. Or I don't recall ever saying anything about the fact that I thought the outcome in this case was not in question. I think that we litigated this case properly, and that shouldn't be held against us, as it seems to be something that they want to talk about, especially in their briefs.
The outcome was uncertain. Doesn't that benefit the appellee here in terms of being entitled to a contingency multiplier?
Well, it does, but you have to read what Mr. Friday testified to. He basically said, and going back to the multiplier, I'm glad you asked me that, was that he doesn't take cases unless he's reasonably sure he's going to win. There's a reasonable chance of success. He's not going to waste his time, as he said, that I'm not going to take a case and waste my time if I don't think I'm going to win. It's kind of like in this case, again, with respect to Mr. Friday, he wants it both ways. He wants to make it seem like he was undertaking this tremendous burden of a case, but yet he's also the expert. He's the guy that is only one of 3 guys in the entire state at the time that would take these cases. And that he's got all this experience. It seems like they're arguing both ends of the so-called stick here. And I'm
not sure he's the only one doing that.
Excuse me, sir?
I'm not sure he's the only one doing that. You're saying that you had the right to and needed to defend vigorously, and yet it was a slam dunk. I mean, both of you seem to be kind of saying a little bit of the same thing in terms of, arguing both points in your favor.
I'll accept that, given the fact that I have 7 seconds to go.
No, I'm going to give you a little extra time. So go ahead. I'm going to cut you off after you've gone another minute or so.
All right. Okay. Then quickly, I want to address the issue of travel time and the issue again of the multiplier. It's their burden. Part of the travel time issue is whether AB and Mr. Bontempo and Florida Carey could get competent counsel. There just simply was no proof that competent counsel couldn't have obtained in 2013. Mr. Bontempo sent out again that one email. Mr. Friday says that he is used by Florida Carey all the time. Mr. Bayer said that there was other lawyers that could have taken this case. And in fact, they did get local counsel. They had Ms. Langford. So the idea that you couldn't get local counsel to work on this case in 2013 is just not true. And with that, I see I've taken my time and I would rest.
All right. Thank you, Mr. Glassman. All right, Mr. Friday. And I'll go ahead and give you, an extra minute or so if you need it.
Thank you, Your Honor. And to address Judge Edwards' specific concerns about the talking at both ends of the spectrum, the response I would give to that, Your Honor, is no attorney takes contingency cases expecting to lose. You take contingency cases because, for whatever reason, whether it's the facts, the law, or an opportunity to develop the law, lawyers take cases on a contingency with the expectation that they can win the issue. That determination is a subjective belief of an attorney in a particular circumstance as to whether or not it is a winnable case, whether or not they can eventually prevail. The next question, though, but with that standard, the standard of the courts and of the Johnson factors that question what was the likelihood of success at the outcome of the case and of getting paid at the end of the case is an unnecessary factor, because every attorney taking these cases presumes they've got a chance at winning. The reason the factor is there is because each of these cases, whether it's related to 790-33 or whether it's an automobile accident, is the attorney takes a risk that their time will be compensated eventually and will be compensated at a higher rate than doing an hourly case such as a divorce case.
Let me ask you this, Mr. Friday.
Yes,
what's your best case on awarding you travel time attorney's fees?
Your Honor, there are, and I apologize to the court for not recalling the name of it. It is cited in the briefs that discusses specifically that sometimes there is a basis for award of travel time where there's no other attorneys that are doing them. And I believe it was a case out of the Tampa area, Your Honor, if I can have
That's okay. You don't need to worry about the name of it. I've got your brief. But here, there was a little bit of a dichotomy, I think, in Judge Orfinger's ruling. First, he found that there's only 3 attorneys in the state who actually handled the cases. But on the other hand, he also said that there were attorneys available in Volusia County who could be engaged. And then, taking all that into consideration, he denied your attorney's fees. Are you asking us to reweigh that evidence or what?
Your Honor, what I would suggest that the approach the court should take in in this case is based on the testimony of the experts and based on the testimony, the unrebutted testimony, and I think the judicial finding that there were only 3 attorneys handling these cases, 2 in Jacksonville, 1 in South Florida. Given that there were only 3 attorneys, that while Mr. Bayer testified he or others could have handled it, the question is also, would they have handled it, and would they have handled it on this fee basis?
All right.
Woodley
All right, I need you to just go ahead and wrap it up now.
Yes, Your Honor. A 1.5 multiplier is insufficient given the actions of the city in this case. We ask the court to find that the time spent obtaining the replevin should have been compensated, and that the city is liable for the attorney's fees in this appeal. Thank you, Your Honor.
Thank you. All right, Mr. Glassman, Mr. Friday, thank you both for your presentation.
Thank you.